Ladies and gentlemen, the Commonwealth has arrested the rebuttal evidence. So in other words, you have heard all the evidence you're going to hear in this case. So what I'm going to do, we have some housekeeping matters to take care of. So what I'm going to do is release you early today. And what we'll do is when we come back at 10 a.m. tomorrow, you will hear closing arguments, and then the case will be handed over to you, okay? All right, so have a good night. Do not discuss the case. Do not do any outside research, please. Okay, thank you.
Hold up. Do you know which counts for striking? I want you to do that.
All right, Mr. Carroll, now your motion.
Yep, cool.
Your Honor, renew my motion to strike previously given. In addition,
Right. Just, thank you.
I'd renew my motion to strike previously given at the light most favorable of the Commonwealth, expecting that evidence would come to light regarding the investigations in this case. It would come to light regarding anything that would appear other than the codefendant, who has every possible incentive to tell the story that the Commonwealth has asked her to tell. Once again, not in the light most favorable of the Commonwealth, we're here at the end of the evidence. The testimony by the codefendant, who appears to tie everything together for the Commonwealth, essentially was a story that, when pushed and questioned, couldn't do anything but say, I don't know. And in fact, at one point, as I asked questions regarding details, and as we know from listening to the lengthy evidence relating to digital forensics, the lengthy evidence relating to blood stain pattern analysis, these require details, and this Commonwealth's case is entirely devoid of details. You've heard from many detectives who were in the defense case, specifically Detective Miller, who was their expert, the expert that they chose not to use. And in that, he indicates that the data, he still stands by the data relating to his executive summary. The only thing that changes is that Juliana Perez Magalhaes decided to come forward. Once again, if someone's coming forward, there has to be some sort of way to test their knowledge, test their timing, test by the dates that are crucial to this case. And in every, despite the fact she walked through with the Commonwealth whatever the story was going to be, she couldn't answer any other questions, or she wouldn't answer any other questions. Judge, with all due respect, it was my position, and we did it. We put on the evidence through the Commonwealth's witnesses, and many of them are in absolute conflict with what she said. This whole entire case rests on her testimony, and rests on her testimony relating to the timing of her trial, the timing of her the health illness, the timing of Brendan's arrest, and the timing of her feeling like she'd lost the ability to defend herself because of whatever she says about her lawyer. I'm not saying that's true, but it was certainly something that she was thinking of. In fact, we saw numerous messages where she talks about almost giving up hope, because if he asks for another continuance, then I don't know what I'm going to do. And so, Your Honor, given all of those facts and no longer in the light most favorable to the Commonwealth, I'd respectfully suggest that Your Honor strike this case. In addition, the motion to dismiss relating to NAPU, it still even more so relies upon what I believe to be testimony that's not truthful and can be shown and has been shown to be not truthful in numerous ways. And I'd respectfully ask that you consider the motion to dismiss.
All right, thank you, sir. Yes, ma'am.
Your Honor, in the light most favorable to the Commonwealth, we have met our burden. It's appropriate that the case be submitted to the jury. Thank you.
All right. Well, in this matter, not weighing the evidence, but the evidence that's before the court, there is a scintilla of evidence for each of the counts. There's 5 counts in 2024, 666, and there's 2 counts in 2024, 873. And there is evidence that can go forward to the jury. The weight that they put on it at that time is up to them. And and as far as the dismissal under NAPU, I again will deny that motion, as I don't find it as as a matter of law that the co-defendant's testimony is incredible. Again, that weight goes to the jury. So based on those statements and what was stated in the record for the previous motion to strike, your motions are denied, okay? All right, so jury instructions.
Your Honor, initially, if the Commonwealth may be heard, and I'm going to turn this over to Ms. Rissler because she has the indictments pulled up. As I'm sure the court knows, the Commonwealth cannot proceed with sentencing on both an aggravated murder within 3 years, as well aggravated murder for commission at the same time. At this point in time, we would elect to go forward on aggravated murder for 2 offenses committed within 3 years, and between the 2, child endangerment and abuse and neglect, we have elected to move forward with endangerment. Ms. Rissler can address which.
Okay, just so I get this straight, I mean, the case law is that both Section 7 and Section A can go back to the jury.
They can, and then if they find guilty on
in
both.
sentencing, I just sentence on one.
Correct. We, at this point in time, feel that it would be less confusing for the jury to simply submit
It's your
on
case, so.
the offenses that we believe we've met the burden of proof for.
Okay, so which ones are you going forward on then? I guess that's Ms. Bristler, sorry.
Judge, we, in case number ending 666.
Yes, ma'am?
So we have counts 1, 2, 3, 4, 5.
Yes.
So Judge, if we strike counts 1 and 2, those being the aggravated murder charges within the same transaction.
Count 1 and 2?
Yep.
When you say strike, do you mean dismiss?
Yes.
I assume no objection? All right, count 1 and count 2 are dismissed?
Yep, that would leave us with counts 3, 4, and 5 in that case number.
Okay.
Then, Judge, if we look to case number ending in 873,
Okay.
and in that indictment, if we look to count 2,
All right.
count 2 would be the
Child abuse.
Abuse and neglect.
yes, that would be the one that we would strike.
So you're striking count 2,
Dismiss,
or
yes.
dismissing count 2?
Yes.
Any objection to that? All right, so we just have count 1 of 873, which is child endangerment, correct?
Yes, ma'am.
All right, so based on that, we need the charging instructions then for the 2 okay, here's the next question I have for you. So count 3 and count 4 are legally the same. Yeah, I mean, if you look at the charging instruction for
666?
aggravated murder, you're just switching the names, but you still have to find premeditated murder, correct? For both of them. So what's the difference between count 3 and count 4?
One is for the murder of Christine, one is for the murder of Joseph Ryan.
Well, but it's aggravated murder, so it's one charging instruction for both of them. The only reason it's aggravated murder is the killing of 2 people.
Correct.
Okay, so how can you have different charging instructions where you're just flipping the names? The one charging instruction would involve both murders.
And
For
Your Honor, the way we
aggravated
drafted them was to say exactly what you just said, to flip the names. One is for the murder of Christine Banfield and one is for the,
In order to have aggravated murder, you have to have 2 murders.
correct.
So the charging instruction has to have both murders on the charging instruction, all right?
Yes.
Do we want to look at the model jury instruction?
And we used the model jury instruction.
Right, so how can you have two of those?
If Your Honor does not, then we couldn't, is Your Honor suggest that we couldn't have two instructions or that we can't have two indictments?
What, your two indictments are proving exactly the same thing. I mean, how is that possible? It's not for the murder of one and murder of the other. Aggravated murder is two murders. So you have one I thought, it's your case, so I thought
Sure.
it was what aggravated murder for one for 3 years, aggravated murder for one in the same transaction. But that's not what you're doing, which is fine, but I don't see.
I understand.
I don't see how you can do two separate aggravated murders when you have to put the two murders in for aggravated murder.
Understood, and I see. that-
Waterfall instructions are different.
Sure.
Because you have first-degree murder
Right,
in one,
and then it splits
first-degree murder
apart.
in another.
Right. And that's how we've written them, is to have a waterfall for each, so that if they find one can be, if they,
What's the difference between the two aggravated murders, though?
Judge, I can look up some case law on this and take a minute, figure out the
Sure,
answer to your
if
question,
you'd-
because I
if
don't
you'd
think
like
I am.
to, I mean, I think I have it tackled here. I mean, aggravated murder for your section that you're going under is number one, that the defendant killed name of both people.
Sure,
And number two, that the killings, plural, were willful, deliberate, premeditated. And number three, that they happened in a 3-year period.
okay, understood, but then the indictment couldn't stand as two counts either.
Well, that's what
That's where
I'm
that's what you're trying to tell me.
about.
Okay,
The one for the same transaction can go back as subsection 7, and the one for subsection 8 can go
Sure.
back as two different aggravated murders. But how can you have two under subsection 8 going back as two
but then what
aggravated
do we
murders?
do, how does the waterfall instruction read when you believe that he killed Joe but not Christine, and
Well,
can then
that's why you
find-
have to do a different waterfall instruction.
So what I was understanding Your Honor to suggest was that there would only be one indictment and one instruction for aggravated,
Right. And
but
then
wouldn't we then need two separate instructions?
Right, or if you find that he only murdered Christine Banfield.
Right.
At first degree, and you have to go down that, or move on to the next, you only
Right.
found that, it would be the
But
second.
at what point do they diverge, right? Because if you don't
After
find
aggravated murder.
aggravated, do you then have a separate instruction for first degree for both? If you find Christine but
Basically,
not
it would-
Joe,
it
and
would
if
be
you
the
find Joe but
waterfall.
not
If you
Christine?
have not found aggravated murder, period,
Okay,
then you may
Right.
find first degree there, first degree here.
right.
Is this making sense?
It is. No, I'm absolutely tracking what you're suggesting. I think that's not the way we've done it, though. So we should probably,
I just don't see, and I'll give you time to go look at some case law and see how two aggravated murders, because the only reason it's aggravated murder in this case is there's two.
right, because there's two people.
Right, so I don't see how two counts of the same of 3 years goes to the jury when it's just the two people.
And I'll admit, Judge, I was just sailing with the indictments the way they were presented with two counts of each, two counts of within three and two counts at the same time. I will need to look into this to determine what the next
Sure.
step forward is.
That's not a problem. I mean, would you rather do this in the morning then?
Yeah, just to make sure that I have the correct answer rather than,
That's fine. I
Okay.
think that's fair. Do you have any objection to that, Mr. Carroll? Or anything you want to add to the conversation?
No, Your Honor, we were just chatting, and so I'm fine with looking into it.
Well, if you want to, and maybe I'm going down the wrong rabbit hole, but
I-
it's just,
Your Honor, I think it bears looking into. I think
Okay.
you raise a good point. If we can, however, then not yet strike counts from the
Okay,
indictment.
that's
We may
fine.
still come back to that same position, but
okay,
we
that's
can
fine.
preserve.
We can do that, so we can get this figured out.
Okay.
And if you come back tomorrow and that's what you want to do, that's fine. I'm just trying to
Okay.
keep a clean record here.
Understood. I appreciate that.
Look, can we have the 9:30 motion, so you want to meet at 9? Is a half hour going to be enough time?
That should be, because we will speak in advance of court tomorrow.
Oh,
and
that would
have-
be, it's music to my ears if it's true. Okay, that would be fantastic. If you
Yes,
could meet ahead of time and maybe agree on whichever way you end up going on them, and we can have those charging instructions tomorrow for whichever
Yes, ma'am.
you go for, I'd appreciate it. Let's meet at 9 then. Let me go let Jamie know we need a court reporter for 9. Okay, great. And we'll be good to go. We'll see you at 9. Anything else at this time then?
Yes.
Oh.
Ms. Perez Morales is no longer obviously subject
Okay.
to enrolled witnesses. I think we need to let the jail know so that she can be returned
To her.
Okay,
Yes.
to wherever she's returned
She
to.
was,
to not segregation.
she was
Oh,
segregated.
okay, so yes, so she has been released. So we'll do a jail card or something to make sure that's taken care of.
Thank you.
Okay.
Appreciate it.
All right, anything further?
No,
All right,
Judge.
All right, we'll see you at 9 a.m.